get some legal analysis on this now. Khumisi Kganare joins us now for more on this conversation. Khumisi, good to have you, and thank you very much for your time. We had a lot of things, and as opposed to the layman, might not make a whole lot of sense, but in essence, one of the senior counsels characterized this battle as a battle that's happening in two domains of law: Section 19, political rights, and Section 20, consumer right. Do they ever come in a space where you've got to look at both and be able to find middle ground?
Yeah, sure. I mean, look, we take a lot of what we do, especially in the legal fraternity, from the Constitution. Yes, there are, some elements of, the political, sphere of it, and there are commercial, elements to this whole thing. And I mean, that's the nature really of trademark law. If we were to follow it in terms of the Trademarks Act, and also an issue of unlawful competition, if we focus more on the private law of competition, or if you may, common law insofar as it relates to trademarks. So this is what we are experiencing now, and the timing of it all. I mean, it's all during the time when political parties are registering to be recognized, so they can compete in the next elections. So yeah, that's where we are, and this is a very important one to resolve.
Yeah. So let's do the housekeeping issues then. The first thing, of course, that they would need to establish is urgency, and the senior counsel says, well, yeah, the question of urgency is simply answered by whether or not one would suffer irreparable harm if the matter is not heard right now. So the ANC is saying, well, if it's not heard right now, the MK party is going to go and campaign using their heritage off the back of the hard work that the ANC has put in, and they'll gain from it. And after the elections, then there will be no way of repairing that harm. Is that correct? Did they make the point on that?
Look, I mean, with urgency, you obviously have to look at when did you become aware of this, issue being prejudicial to you. It's obviously something they were not aware of only, say 2 weeks back. They've known about the existence of the MK party since last year. So those are the kind of things that would be considered by the presiding officer in determining whether or not there is a case for urgency here. And I mean, they are coming short, if you may, in respect of the reasons they advanced. You would look at it at the pressure that is mounting perhaps towards May, and that wouldn't be necessarily a reason that would be accepted in a process like this. As soon as you know that this thing exists and is a problem, or it might cause a problem, harm, or irreparable, either real or perceived, you need to do something about it immediately. And if you waste time, like in this instance, then it becomes somewhat of a higher hurdle for you to jump.
Yeah. Are there time durations to this type of thing to say, well, if you didn't act within 14 days, like we heard from the electoral court, or if you didn't act within 30 days when you saw there's an infringement of your trademark, then, well, there's no urgency really?
Yeah, look, I mean, for instance, one example would be if there's something that's that I consider urgent, and I come to know of it today, ordinarily court would even allow me to just, put my things together this week. Next week, Tuesday, we are in court. That's how quick even the judicial system is prepared to hear people that have got urgent issues. And you would get to a situation where sometimes urgency is, classified. Some would say, it's semi-urgent, therefore it can wait 2 more weeks, or it can wait a month, or even 2 months in some instances. But beyond that would really be to stretch it.
So let's look at the other issue then that would have come up, which I suppose one would have thought that would be actually firstly the big issue that you'd need to discuss, one of the locus standi, whether or not these are the people who have a complete or even unique rights or sole rights to this particular trademark to be able to come and raise an issue to say there's an infringement on our trademark. The ANC believes they've got a deeds of assignment with the legacy project, which of course gives them full right to use this and use it to its fullness in terms of the rights. How much weight do these deeds of assignments hold in a matter?
Look, Thabo, there's a lot of issues here. Some misplaced, not well coordinated. For instance, not only is there an issue of locus standi, there's also an issue of jurisdiction. And before we even get to a point, that really deals about the actual trademark, who owns it? Is it registered? If you have registered it, then it becomes very easy for you to engage in this battle and really protect your mark against perceived or real infringement. For instance, if you approach a matter like this, it would be, in two ways, one of two ways. If you have it registered, then you just employ the provisions of the Trademarks Act to say, look, I went through a process of protecting this mark, and at the end of that process, I was issued a certificate. Very easy case. Here's the certificate. Somebody is infringing my mark. We are in the same market. Trademarks are classified in terms of classes, services and goods. If we are in the same market, then it's a problem. And it's very easy for me as the proprietor, the person that owns the mark, to then fight, successfully in most cases. But if you do not have a registration certificate, then you would have to approach the issue by way of, private, or if you may, common law, particularly passing off or unlawful competition, for which we do not have legislation, like the Trademarks Act. And there, your battle really becomes insurmountable, if you may. And where you get then parties entering into assignment agreements, that is just an agreement to say, look, we enter into this agreement because I have a certification for the mark, or if I don't have registration certificate, then I have been using this mark without a certificate for a long time. There's evidence and all those things that I can bring forward to prove goodwill, good faith, or whatever. Then based on that, we get into an arrangement to say, look, I am licensed you, if you may, we can call it a license, to use in this instance. Yeah. That, again, is not a registration certificate. I mean, for instance, we know that the ANC only went to, the CIPC, which is responsible now for the legislation part of protecting your trademark, to file for registration in September last year. And when you file, you're not getting a registration certificate. It's just a process to say, look, I propose to register, have a look at this mark in these classes that I've identified. I think there's about 4 or 5 that the ANC has identified. And you then have to go through a process, Thabo, of about 2 or 3 years. Back in the day, it used to take longer. Now with systems, it's much quicker, but you're looking at about a year or 2 before you get to a point where you are issued a registration certificate. So if there's no registration certificate, it becomes very difficult to then fight.
So you're saying the MK Legacy Project would have taken at least good 2 years of the process, and the ANC would have been well aware of these folks who are, I presume, wanting to register the trademark of uMkhonto Sizwe.
Yes. I mean, it's you just produce a certificate. If you started with the process, and we know that, for instance, the legacy projects, it's something that started, I think, about 10 years ago. By now there must have been certificates that talk to this particular mark, be it the name uMkhonto Sizwe or the image as we know it. Protecting it as your intellectual property. Yeah. I haven't heard anyone saying, here's a certificate, we are producing it in these proceedings to support our case against infringement by the uMkhonto Sizwe party.
So does that then almost starts and ends the case right there, where the courts can just turn and say, well, you're not giving me a certificate, so you are not even the right person to be bringing this matter to this court, even if you were to argue the question of trademark?
Yeah, not really. Look, even if you don't have a certificate, like I said, there's another process of common law that you can explore. And hence, we see counsel today, hinging mostly, if you may, on passing off.
Okay.
Because that's what you would have as, another way of really putting your case across against infringement, to say, look, even if we don't have a certificate, we have been using this mark for a long time. It has developed reputation, goodwill, and as a result, we believe we have rights over this thing that must be protected against infringement. But again, it doesn't end there. I mean, you will have to be in competition with each other, if you may. That's why in some instances, Thabo, you would find people that file for trademark protection. When it comes to the stage of advertising the mark and opening it up for possible objection, then people sit around the table to say, look, we saw your mark, we are not in the same market, okay, can we discuss consent and conditions of use? If for instance, you are SACP, you use a black star, and All Star Converse has an issue with you as SACP registering the black star, then you sit around the table to say, look, but we're not in the same market. We're just doing this thing for political reasons, and you're never going to find us, next to each other in a store where we will be confusing people. We are doing this just like in this instance. ANC doesn't have locus standi. Their mark wouldn't necessarily, they can't even go that route. And you find an instance where perhaps if legacy projects were to have an issue with this, again, they are not in the same space as the uMkhonto Sizwe party. So those are things that would have to be looked into, Thabo, at the end of the day when this matter is decided on.
Sounds very complex. Okay, you've raised the question of jurisdiction. So the kind of arguments we were hearing is to say, well, you started this process with the IEC. That was the right place to actually go there and raise this issue. And you should have then gone further to the electoral court and ventilated there. But you thought, no, we're not even going to go there because you changed your mind and thought this is the wrong platform to be in. We are going to go to the High Court. And they're saying, well, you've already elected anyway by firstly going to the IEC and presenting this matter. So you can't now change. You're supposed to continue there in that process and appeal the outcome that came from the IEC.
Yes, I mean, there's always issues of concurrent jurisdiction, and it's normal. And you get forums that are specialized. In this instance, the electoral court would be allowed to deal with trademark or mark or name issues insofar as they relate to the elections. And if you take it there, I mean, what are the chances of you really, as the ANC in this instance, getting an order that is in your favor when we look at the actual marks that you are going to be using on the ballot paper, that of the ANC and that of the uMkhonto Sizwe party, they are not confusingly similar. And I mean, those are very important things to consider.
Yeah.
And they are not confusingly similar. And as a result, you're not likely to, get your way with the electoral court. You would then want to take this matter to a different forum, which I think is happening now. And even in this instance, do you really have locus standi? Are you the right person to be bringing this fight against the uMkhonto Sizwe party? I don't know. And in this forum also, there's already issues of agency and jurisdiction. We would then have to get to also issues of why do you really have an issue with this logo? Are you competing? If we were to define the market, Are you guys in the same market? Are you competing in respect of some particular services or goods, if you may? And if the answer is no, then we know that perhaps you're not likely to get what you want as a person who has now this issue with the uMkhonto weSizwe party.
Yeah. So, I mean, let's talk then the legal concept of passing off. It falls within the realm of false representation, if you like, directly or indirectly, by passing off a particular trademark to consumers to the benefit, much to the detriment of the other party that says they own the trademark. So maybe not directly in competition, but the ANC saying indirectly, of course, MK party would be falsely representing itself using the MK trademark and heritage and goodwill to get people to vote for it. How difficult is it to prove that?
Yeah, look, one of the things to be considered, Thabo, would be we take an ordinary man in the streets. We already know the history insofar as uMkhonto weSizwe is concerned. Directly, yes, we can agree, perhaps not directly. Indirectly, again, uMkhonto weSizwe is not representing itself as the ANC. You know, maybe indirectly you would say then they would want to piggyback on the history insofar as it relates to uMkhonto weSizwe and how it's linked to the ANC. But bottom line is already we know that there is a difference here, especially when it comes to, if we were to define the market, when it comes to voting, the voting market. There is ANC and there is uMkhonto weSizwe party. Perhaps if there was another uMkhonto weSizwe party, I don't know, war veterans, perhaps there would be a case if they were also in this market, if we were to define it as the voting market or voters market. So yeah, passing off also, you don't just look at it in vacuum. You would have to look at a lot of circumstantial evidence, and in this instance, it becomes that difficult because you don't have a certificate of registration that you can produce that supports you owning this intellectual property. So you would have to really, and I see maybe that's why, we are going back into history about how uMkhonto weSizwe was formed and issues about it having been disbarred in 1994 and all those things. And it's necessary, we have to do that because we are facing a case where there is no registration certificate.
Appreciate your time, Khumisi, and thank you very much for coming on.